this is the most important, was the holding of a separate meeting of the legislative party. And that it was suspected that the delinquent MLAs tried to establish a new political party using the name Shiv Sena or Bala Sahib. The extract of the said letter is reproduced below. I don't have to read it. Only indicated a possible split in the Shiv Sena legislative party and not the party itself. So your lordship knows, Malas, that can never amount to a split in the party. So, Malas, that's point number one. That is the 21st June letter. Your lordship will remember the 21st June letter only relates to the legislative wing. Malas, that is the 31 MLAs at that point in time.
You are almost near to completion of argument.
No, on the list of dates, Malas. Now I'll come to the issues.
During list of dates, legal issues have also been raised.
No, Malas. No, in fact, very, very serious issues that arise in the interpretation of 29.
But we are
No, I know that. Your lordship never does that. But I will also never, Malas, take time which is unnecessary. We've never done that, Malas. That's not part of our, learning that. Malas, we just hand over our written submissions. I'll deal with the Election Commission first, Malas. I'll deal with the other issue, Malas, of...
Not on the argument.
Yes, just the arguments and the relevant pages, Malas, so that I can take your lordships.
Right.
So, Malas, the impugned judgment dated 17/2/23. This is Que, Malas, para 15 of the Symbols order. Is in 4 material parts, Malas. Determination that a split has occurred in the Shiv Sena is set out in paras 58 to 70. And, Malas, page 485 to 492. Determination that the test of the party constitution is not appropriate to decide the disputes in these paragraphs. Determination that the appropriate test is the test of majority, but the consideration of majority in the organizational wing does not lead to a satisfactory outcome is in those paragraphs. And determination that majority in the legislative wing is decisive in awarding the party symbol to the respondents is in these paragraphs. Now, let me go to the first paragraph, Malas. That is determination that a split has occurred in the Shiv Sena. Kindly come to paragraph 58.
'58 of the impugned judgment.
Yes. Yes. That's in the compilation, Malas. Convenience compilation. Page 485. Page 485.
Page number, Mr.
485. Paragraph 58 at 485. Must you bear that?
Yes, whether a split has occurred.
Yes, exactly. That's the first part. So the petitioner in his petition dated 19/7 has submitted that a split had occurred in the Shiv Sena whereby two groups, one led by him and the other by the respondent, had emerged. Petitioner had relied on the fact of political alignment and alliance with political parties of different ideologies as the reason for the emergence of such split. He further submitted that a majority of the members of the legislative and organizational wing of the Shiv Sena were supporting the petitioner. On behalf of the respondent, it was fervently argued that the petition only indicated a possible split in the Shiv Sena legislative party and not the party itself, and that political realignment could not be a ground for split in the party. It further argued that there should be a vertical split in the party and that such split should not be of evolving nature, but rather should have occurred at a particular point in time. With regard to the issue of political alignment of party, it is submitted that the same is of no relevance for the Commission to decide a dispute for the purpose of 15. However, emergence of a separate group or rival faction in the party, which is the result of any political alignment, either solely or in combination with other factors, depending on the facts of the case, can be essential for the Commission to decide about existence of a split. So it says in the present case, there are other factors which indicated that a split in the Shiv Sena The indicator of the emergence of a split in Shiv Sena was the holding, now this is the most important, was the holding of a separate meeting of the legislative party. So your lordship knows, Malas, that can never amount to a split in the party. As per the petitioner, a meeting was held by a group supporting respondent 24 to 55 MLAs of the SSLP, that is the Shinde group, attending the meeting and passed a resolution for removing the petitioner as leader of SSLP, whereas at the meeting held by the petitioner, 34 to 55 MLAs of SSLP attended the meeting and reaffirmed their faith in the petitioner as leader of SSLP. It is also pertinent to mention that both the groups appointed their own leaders as well as chief whips of so-and-so. Both the groups also initiated disqualification proceedings against MLAs who were supporting the other group under Rule 6 of the Maharashtra Legislative Assembly disqualification rule. Similarly, both the groups appointed their own supporters as leader of the Shiv Sena party. So, Malas, that's point number one. That is the 21st June letter. Your lordships will remember the 21st June letter only relates to the legislative wing. Malas, that is the 31 MLAs at that point in time, right? And the commission says that amounts to a split in the party. Contrary, Malas, to para 15, contrary, Malas, to the judgment of this court. Now, Malas, kindly see another part. So this is one fact. Another pertinent fact was that the letter of 25/6 received by the commission from Anil Desai, wherein it was mentioned that the petitioner and some MLAs under his leadership were indulging in anti-party activities, and that it was suspected that the delinquent MLAs tried to establish a new political party using the name Shiv Sena or Bala Sahib. The extract of the said letter is reproduced below. I don't have to read it. And then 62. Subsequently, the commission also received 3 separate letters dated 1st July from Anil Desai, wherein it was stated that Eknath Shinde, Tanji Sawant, Uday Samant, Gulab Rao Patil had indulged in anti-party activity and have voluntarily given up membership of the Shiv Sena. In the said letters, it was further mentioned that the said persons had been removed from their respective position in the Shiv Sena, set up by Shiv Sena Paksh Pramukh, respondent under the provisions of the party constitution. This commission is of the view that the aforesaid letters were further evident of emergence of a rival group in the Shiv Sena. So what's the conclusion? So, therefore, he says these 3 communications, 21st June, which I read to your lordship, 25th June that I read to your lordship, 1st July that I read to your lordships, he says amounts to a split in the party. Now, if that is the logic, then he can't assume jurisdiction because a split in the legislative party can never be a split in the party.
Paragraph 63 first line.
I'm coming, Malas. The next point to be
That's how it comes to the party.
I'm coming, Malas.
Says
The
that
next,
since there is a split in the legislative party, we'll infer the split in.
how can you do that?
Consequential.
That's the problem.
That's
my argument, Malas.
argument.
That's precisely the point.
That whether a split of the legislative party
Can never be a split in the.
by itself of a split.
That's correct. And he relies on these 3 documents, 21st June, 25th June, and 1st July, which I've read. So, Malas, if it doesn't amount to a split, he can't assume jurisdiction. My argument is, Malas, he assumes jurisdiction on the basis of these 3 documents. If these 3 documents are not evidence of a split in the party, he can't get jurisdiction under paragraph 15. Because jurisdiction under paragraph 15 only comes when there is a split in the party and then 2 rival groups emerge. So that's my first submission on the first point. Now come to the second one, para 63. The next point to be considered is whether a split in the legislative wing of the party results in the split in the party. But that's what he's already said. It is stated that under paragraph 15 of the Symbols Order, the Commission adjudicates a dispute when rival groups emerge in a recognized political party. The recognition is dependent upon electoral performance of the concerned political party, as explained in CA and CB. Well, 6A and 6B results say that whether you're going to be national party or a state party, that depends on the percentage of votes that you get. As your lordship knows, that's the standard test. That doesn't apply in this case. That's of no relevance. Thus, the aforesaid provisions indicate that the electoral performance of a political party is not only essential for getting recognition under the Symbols order, but also for its continued recognition in view of the said legal position. This commission is of the view that for any dispute involving a recognized political party, where the dispute primarily revolves around the claim over the recognized symbol of the concerned political party, the legislative wing of the party cannot be viewed in isolation. What's the logic of that? There is no doubt that it is the organizational structure of the party, including the grassroots workers who toil and labor. This is all irrelevant, according to me, Mullahs. Who toil and labor and turn an association of individuals into an electoral machinery, which then contests an election, and the resultant fruit is the popular vote received by it. The final product of the whole cycle is the election of legislators, such as members of parliament, but we need not go into that. Now I kindly come to it is also apposite to mention that most often members of the legislative wing are also part of the organizational wing, no doubt about it, of the party. In the present case, the petitioner is a member of the Legislative Assembly, was also a Shiv Sena leader, part of the organizational structure of Shiv Sena before the dispute arose. Similarly, the respondent, who is a member of the Legislative Council, served as Shiv Sena Paksh Pramukh, the position which is the very apex of the organizational structure of Shiv Sena. If the 2018 constitution of the party is seen, now he relies upon the 2018 constitution, which he doesn't look at later. So now, Mullahs, he deals with dispute case number 1. I already, Mullahs, have already made my point on this, that this doesn't apply at all. This is in my favor. This decision is in my favor. Judgments note there has to be a split in the party. Your Lordship, I indicated that, Your Lordship. This judgment itself says there has to be a split in the party.
There are 3 decisions cited.
Yes, but the 2 decisions in my favor. The third one, Mullahs, he distinguishes, and then dispute number 1 of 1994, which he relies upon, is completely inconsistent with what the judgment says, which Your Lordships haven't read, which I'll show to Your Lordships. So, Mullahs, this is one judgment. Then he comes to Indira Gandhi and Brahmanand Reddy. There also proceeded on a split in the party. This judgment also doesn't apply, and he relies upon. Then dispute number 1 of 2017, Samajwadi Party, also, Mullahs, split. That's between Akhilesh and Mulayam Singh Yadav. That was a split in the party. So, Mullahs, he refers to these 3 judgments. All of them talk about split in the party, not in the legislative wing. Then, Mullahs, what he does, he concludes, in view of the aforesaid facts, para 70, Mullahs. So then I'd have done with the first submission.
Answer is in para 6 of the submissions.
Yes, kindly see, in view of the aforesaid, the commission is of the view that a split has not only occurred in the legislative wing of the Shiv Sena, but the party itself. Where did he get it from? He relies on the decisions which talk about split. So now he assumes, Mullahs. So this is now my conclusion on that is in paragraph 6 of my submission. Just have a look at that.
Page 2.
Page 2.
Today's submission.
Yeah, my submissions, today's submission, paragraph 6. So what I'm doing is I'm referring to the order and then the submission. It's easier for your Lordships too. It is respectfully, I'm sorry, para 6, it is page 2, Mullahs. It's respectfully submitted that this interpretation of the commission is contrary to a plain reading of para 15 of the Symbols order itself, which requires that there must be rival groups in the political party. It says, when the commission is satisfied on information in its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party, the commission may, after taking into account all the available facts and circumstances of the case, and hearing such representatives of the section or groups of other persons as desired to be heard, decide that one such rival section or group or none of such rival sections or groups is that recognized political party, and the decision of the commission shall be binding. It's on the assumption that there is a rival section of groups in a recognized political party, which he says is because the legislative party split. Therefore, I recognize that as a split in the political party because one of them held also a post in the political party. That's the logic, right? Now kindly, let's come to para 7 of these submissions. The emergence of rival factions in the legislative party cannot in law lead to an inference that there are rival groups in the political party itself. To hold otherwise would amount to conflating the legislative party with the political party, Justice Chandrachud's Muller's order, which would be in the teeth of law laid down in Subhash Desai to the effect that the legislative party and political party are distinct and separate. In the judgment compilation, which your lordships will find, compilation final, yes, which I gave last time to your lordships, and
Page 69.
page 69, Malats. Yes. Yes.
The very first judgment.
Yes.
Yes.
Power to appoint a whip and the leader of the political party and legislative party are distinguished concepts. At page 69. And the judge says that, Malats, he defines legislative party in relation to a member and political party, original as the political party to which the member belongs. And then the court, Malats, comes to the conclusion. I'll give the conclusion at para 109. The political party and the legislative party cannot be conflated. The contention of the respondents that political party and legislative party are inextricably intertwined is erroneous for the following reasons. And I read para 109.1 and 2. Parliament in its constituent capacity was conscious of the necessity of not allowing anti-defection laws to stifle intra-party dissent and the freedom of expression of legislators. It was with the objective and the defenses of merger and split, which were later omitted, were introduced. The 10th schedule confers legitimacy to the actions of the legislators, which would otherwise lead to disqualification of a substantial number of legislators, 2/3 in the case of a merger, 1/3 in the case of the erstwhile provision for a split, disagree with the political party. The 10th schedule recognized the independent existence of the legislative party to the limited extent of presenting a defense to the actions of the legislators, which would otherwise have amounted to defection. So when I file a disqualification, he can, in his defense, say, I have 1/3, and in the case of merger, I have 2/3. 1/3 is gone, 2/3 remains in the case of merger. Section 29A, this is important, of the RPA requires an association of individuals called itself a political party to be registered with the ECI. The party need not have returned candidates to the assembly to be registered as a political party. Under the Symbols order, a political party receives recognition as a state party or a national party. That's 6A and 6B, based on the total number of candidates returned to the assembly by the political party and or the total percentage of votes secured in the election. The purpose of requirement under the Symbols order is to identify whether the political party has a substantial presence in the electoral fray to freeze the electoral symbol for the party. Symbols order does not refer to an association of legislators, deors the political party. Under the 10th schedule, it recognizes the legislature and the political party. The reference to provisions of the Symbol order to argue that the concept of political party and legislative party are intertwined does not hold merit because the concept of the legislative party is not recognized in the Symbol order. In fact, the Symbol order doesn't talk of the legislative party.
Demolishes the reasoning of the.
So it demolishes the reasoning of the Election Commission straight away, Malad. And this is a Constitution Bench judgment. So, Malad, that's on the first part. Then para 8, Malad. In fact, the erstwhile para 3 of the 10th schedule, now this is important, contained a similar requirement in para 15. Where a member of a house makes a claim that he or any other member of the legislative party constitutes the group representing a faction which has arisen as a result of a split in the original political party. And such group consists of not less than 1/3 of the members of such party. So, again, the same concept. The split must occur in the original political party. Then, 1/3 of the legislators can take a defense. Right, Malats? Now, that argument was made in Rana, Malats, which is the court case cited, Malats, in para 9. And para 38 says of Rana, acceptance of the argument that the legislators are wearing two hats, one as members of the original political party and the other as members of the legislature, and it would be sufficient to show that 1/3 of the legislators have formed a separate group to infer a split or to postulate a split in the original political party would militate against the specific terms of para 3. So there you are, Malats. Exactly what the commission has done, Malats. Prohibited both under paragraph 3 and otherwise prohibited because of Subhash's judgment, Malats. That paragraph speaks of two requirements. One, a split in the party, and two, a group comprising of 1/3 of the legislators separating from the legislative party. By acceding to the two-hat theory, one of the limbs of para 3 would be made redundant or ocious. Such an interpretation is not warranted by the context. It is also not permissible to assume that Parliament has used words that are redundant or meaningless. We therefore overrule the plea that a split in the original political party need not separately be established if a split in the legislative party. The same logic, Malats, with the greatest respect, would apply. Now, Malats, the Honorable Election Commission, in the impugned judgment, has erroneously placed reliance on two judgments to arrive at its finding regarding split in the political party based on a split in the legislative party. However, both the judgments do not support the proposition. In both cases, split in the original party was categorically noted. It says both parties claim to have majority support in the State Steering Committee, and the Commission categorically found that a split in the organizational wing of the party has occurred. So that's the first judgment he relies upon. The second is Samajwadi. Both parties claim to be the president of the party. Commission arrived at a clear finding that there were clear manifestations of a split having been formalized on that day. Therefore, the impugned judgment, insofar as it assumes jurisdiction under para 15 of the Symbols Order on the basis of a split merely in the legislative wing, is unlawful and liable to be set aside. If I'm right in my submission, Malats, then the assumption of jurisdiction by the Commission to decide this matter is erroneous. And therefore, everything else that follows, Malats, is illegal.
तो दोस्तों, माननीय सुप्रीम कोर्ट में चल रही इस बड़ी सुनवाई से साफ हो गया कि लड़ाई अब सिर्फ शिवसेना की नहीं बल्कि देश के लोकतंत्र और दल बदल कानून के भविष्य की है। माननीय अदालत इस पूरे मामले के हर कानूनी पहलू की बारीकी से जांच कर रही है। कल इस मामले पर अगली सुनवाई होगी जिस पर पूरे देश की नजरें टिकी हुई हैं। इस पूरे कानूनी विवाद पर आपकी राय क्या है, हमें कॉमेंट्स बॉक्स में जरूर बताएं। जय हिंद दोस्तों।